crowd, attracting the crowd. Entertainment news, it's all in one place. Come join the fun, let's set the pace. From social threads to the community posts, we link up the hearts coast to coast. We build the ties in our local scene. Keezmobile keeps it super clean. Swipe up for the latest, scroll down for more. We're more than news, this is community lore. In a world that's big, we make it cozy and bright. Keezmobile show flies you through the night. At Keezmobile show, we're living out loud. Resourceful and proud, attracting the crowd. Entertainment news, it's all in one place. Come join the fun, let's set the pace.
It's our time, bitch! We've been waiting all motherfucking year, and it's our time to shine! Are y'all ready? Let's go! Hit me! Woo! Sagittarius, get the fuck up, bitch! We ain't pop shit all year, did not do shit! It's time to show out! Let's go! Ha! 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 It's our time, bitch! We've been waiting all motherfucking year, and it's our time to shine! Are y'all ready? Let's go! Hit me! Woo! Sagittarius, get the fuck up, bitch! We ain't pop shit all year, did not do shit! It's time to show out! Let's go! Ha! 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 It's our time, bitch! We've been waiting all motherfucking...
Hello. Hey, y'all. So I'm going to get right to it.
All right, ladies and gentlemen, can you all hear me? Okay, your day started out something like this. You came here from wherever you live in our great county. based on a notice that was probably on your nightstand, your refrigerator, or your junk drawer, or some other place you keep stuff in your house. You took one of means of conveyance to include being dropped off this morning, and then you came here at dark 30, and you came up here to the 7th floor, and you've been sitting around for the day. Is that your kind of experience? All right, I got a notice on my fridge. I'm coming up here to do that on the 12th. So everybody gets called for jury service at some point in time. But jury service, I would submit to you, ladies and gentlemen, is one of the most important things that we do as a citizenry. And the U.S. flag that's behind me is the biggest representation of our responsibility to serve as jurors. There are young men and women who come from every hue and cry, every religious background, who are in all the four corners of the world, ready to give the last full measure, so each one of us can feel irritated and have an opinion. So I would just ask that you respectfully kind of keep that in mind, or in conjunction with what I'm going to tell you over the next several minutes, okay? This is not a perfect process. If it were perfect, you would have come up here and we would have got started at 9:01. But there's a lot of things that happen behind the scenes of justice that aren't explainable at the time that we're going through them. But rest assured, they're to ensure that each person under our U.S. and Georgia Constitution enjoys a fair trial, a lawful trial, and a just trial. So many of those things happened this morning before you got here, and it just took a little bit longer than what we expected. So you're probably asking yourselves, well, what's going to happen now? You know, we've been here all day long. I'm going to tell you. What's going to happen in just a few minutes is you're going to watch a video that has the instructions for this particular trial that you've been summoned for, as well as the indictment. It's a reading of the indictment. Now, before you all take that apoplectic breath, I'm going to tell you that the total length of time is going to be about 3 hours, 45 minutes. It's like Avatar, but, you know, hopefully you like that. But in all seriousness, it is going to last about 3 hours and 45 minutes, and we're going to break probably about every hour and 15 minutes and go ahead and let you all take comfort, and then we'll show the rest. Once that is complete, so it's 3 separate, you know, sittings of that particular juror video, you will then be asked to fill out a questionnaire. The questionnaire, once you complete that, then you're done for the day. Only those of you that wish to be examined for hardship, I'll ask you to come back on the 9th of January to courtroom 1C in this courthouse, if and only if you want to be examined for hardship. So the letter that Ms. Von Kelch and her team gave you this morning kind of has some information on it about your juror number. Okay, all right, okay. You're gonna get one, okay? All right, okay. All right, Amy, don't do that to me. All right, so you're gonna get a letter, and your letter will correspond with a number. And then you'll need to call the particular number on this letter, and it will tell you when you need to report. Now, the only people that definitely need to report on Monday the 9th will be those people that want to be examined for hardship. If you don't want to be examined for hardship, then you'll use this letter, and at some point in time, every night, Ms. Von Kelch and her team are going to tell you, you need to call after 5 o'clock and check the recorded message line to see whether or not your particular number or group needs to come in. Okay? So that's what's going to happen short term and long term. Now, I know with every group, because I was probably one of them, that kind of thinks this. Well, you know what? My fund meter's pegged, Judge. I'm not coming back on Monday. You can't make me come back. What are you going to do? Well, unfortunately, if you don't come back on Monday, I will send these nice gentlemen who are wearing these gray and black uniforms to come visit you, either at your home or your office, and they will force you to come back, and we'll have a very uncomfortable conversation. Let's not make that a reality. If you want to be examined for hardship, please come back on Monday at 8:30, courtroom 1C, and I and the lawyers will go ahead and hear your concerns as to why it is that you may or may not be able to serve as a juror. Now, you probably ask me, well, can I do that today? Judge, I don't care what time of day it is. I want to be examined for hardship today. I unfortunately can't do that. This space has been rented out for a wedding at 7 o'clock, so I got to get out of here, okay? No, I'm serious. By the time you all finish the video and we finish you filling out the questionnaires, we're done for the day. I've sucked up as much of your time as I possibly can do for the day, and I really appreciate your patience on behalf of Amy Von Kelch and her team in jury services, as well as our advocates, who you'll get a chance to probably talk with a little bit later on. Okay, so just to recap the most important points. Going to see a video. It's going to start pretty soon. We're going to go about an hour and 15 minutes. We're going to stop. You're going to take comfort for those of you who want to take comfort. We're going to do that 2 more times. Once that's complete, you're going to fill out a questionnaire. Once you're finished filling out the questionnaire and you get your letter, which gives you the instructions that I just mentioned, you'll be free to go. If you wish to be examined for hardship, you'll need to come back on Monday, January the 9th, courtroom 1C. You'll not come back up here. You'll come directly to 1C, and then we'll examine you for hardship. Okay? So with that, ladies and gentlemen, I hope by way of explanation, I know that doesn't alleviate what you've gone through today, but we really appreciate your patience, because without you, we could not conduct business in the criminal and civil justice system.
Oh, please be seated, everybody. I'm sorry. All right, Mr. Shard, sorry for the delay. Go right ahead, sir.
Well, Your Honor, based on some information that I've learned about today, I'm going to ask if Your Honor would permit me to withdraw the bond motion for the time being, and allow me to refile should circumstances change. There's some things I need to talk to my client about, and I think that would be in the best interest of Mr. Jackson at this moment.
Does he go by Mr. Jackson or Stillwell? Either one.
He goes by Mr. Jackson.
Okay.
But he is also Mr. Stillwell in the indictment.
Okay. All right. Mr. Stillwell, your counsel here is going to withdraw your bond motion for the time being. He'll talk with you a little bit later, if he hasn't done so already, about about refiling it or potentially taking some other steps. Okay. All right. So, sir, you can be excused at this point in time, sir. I appreciate your patience. Yeah.
Can we arraign him? I'm sorry.
Yes. Before you go, though, hold on, sir. Mr. Stillwell, hold on. Before you go, Mr. Chart, would you like to otherwise have the court waive formal arraignment, have the court enter a plea of not guilty on behalf of your client, and for you to have at least 60 days from the date of receipt of discovery to file any motions?
All those things are my intention. We do wish. Would you like me to restate them, Judge, for the record? What you just said?
Yes, to weigh in.
We do waive
formal arraignment.
We do waive formal arraignment. We wish to plead not guilty, and we would ask for 60 days, at least 60 days from the receipt of discovery, in this case, to file motions.
Granted.
Thank you.
I will go ahead and, as I said earlier, on the 18th of August at 9 a.m., we will have a proffer session and waiver session on the record for the various individuals that we indicated earlier. Okay?
Yes, Your Honor. Thank you.
Okay. All right.
And Ms. Sherrill, I will set your client's trial for 9 January of 2023.
Yes, Your Honor.
Okay, all right.
Hey.
Mr. Steele and Mr. Weinstein, I'm prepared at this point in time for you to go forward with your renewed motions for bond. So, Mr. Steele, do you want to go ahead and begin, sir?
Yes.
Since I know you need to be someplace else.
Of course.
Okay. All right, go right ahead then, sir.
Good morning, Your Honor, Madam Prosecutors, Mr. Prosecutor, all the lawyers here on behalf of the other people, on behalf of Mr. Jeffrey Williams, Mr. Adams and I would like the court to reconsider its denial on 2 previous occasions of bail. We filed this motion on April 24th, 2023, and we allege that Mr. Williams has been in custody since May 9, 2022. It's the date of his arrest. As the court previously heard, and if you need me to go over it, I will, but I'm assuming that this honorable court remembers the previous bond hearings and all the witnesses and exhibits that we placed before the court.
I do, sir.
I assumed you did. Mr. Williams, as you know and remember, did not flee when law enforcement officers came to his home on May 9th, 2022. He came out of his house. He called me, actually, and then came out of his house and was not in any way anything but compliant. It's now been more than 14 months so far, as the court may know and remember. The only potential nutritional foods consumed by Mr. Williams since May 9, 2022 include carrots, rice, lettuce, beans, and hot dogs. He mostly consumes products which have absolutely no nutritional benefits, which are M&Ms, chips, other processed or artificial bagged chemical substances. The lights, as the court may remember, in the small, isolated, solitary cell that Mr. Williams is housed in an off-site county. The lights are always on. They are brighter than the lights in this courtroom. So sleeping with bright lights in his face all the time, if he can get to sleep. And that is a form of torture which is not compatible with necessary restoration, sleep, restorative sleep required for Mr. Williams, who is a person on trial and needs to assist his counsel. Your Honor, this lifestyle for the past 14 plus months has caused physical harm to Mr. Williams. As the court recalls, he was taken to the hospital. If the court does not know, and Mr. Williams gave me permission, it is for his kidneys. Mr. Williams was raised in total poverty. He is used to not seeking medical help because he could not afford saying when he was injured or hurt. But he comes in this courtroom every day, writhing from pain from his kidneys. The kidneys removes the waste and extra water from the blood, evacuates through the body, through urine to maintain balances of the body's substantive fluids, to keep proper balance and levels of potassium, calcium, and sodium. The diet consumed by Mr. Williams endangers his health. Pretrial incarceration, Your Honor, is not supposed to damage a person's mind, spirit, or body. It is not for punishment. And this physical incarceration for such a long period of time, and the trial is estimated to last 6 to 9 months, and that's a considerable amount of time. The court has always said, I will put you on trial right away. I'm very aware that I denied bond to your client, and we appreciate that. We filed a demand for speedy trial statutorily and constitutionally. But it is still a long time. As the court may notice, it takes note of Mr. Williams, he has gained tremendous weight. If he's weighed now compared to the time he weighed on May 9th, you will see how much weight he has gained. He does not fit into his clothing anymore. He has no new clothing, and this is a problem caused by the kidneys and the lack of nutrition and exercise. Your Honor, the support for the community is still here with Mr. Williams. It remains here, as I previously showed this honorable court to a packed courtroom. There are people who have not wavered at all. His family is all from this area. They love him, devoted to him. I speak with them weekly, if not more. His friends have stayed with him. Co-workers of Mr. Williams in the music industry. One is a gentleman who is on your screen in courtroom 8H, as in happy. His name is Jeff, which is Geoff, Ogunlesi, Ogunlesi. He has flown across our country to be here today when he found out that the honorable court set the hearings on Tuesday. He is in, if you need him, he is in courtroom 8H, and he will speak to the court if needed. There are professionals of the highest, officers of publicly traded company, the record label, that are on your Zoom. Mr. Kevin Liles, Liles, and he authorized me to tell you that he again embraced in total his previous sworn live testimony before this honorable court, and he stands by it with all of his power and might, and is willing to answer any of your questions that you would have with the prosecution for bond for Mr. Williams. Within this past month, Your Honor, Mr. Williams released a record. It was
Now, I'm going to object to this proffer or opening or this portion of it as irrelevant to a bond hearing.
I can answer that if I need to. It goes to his employment and his steadiness, employment in the industry and in this trial at this time. He has still maintained total employment and he's still active.
Okay, all right, I'll allow it.
He is a number, that record, Your Honor, became the #1 rap record in, you know.
Objection, Your Honor, I didn't finish my objection. Objection to as to.
What's the basis? Relevance? I'm going to overrule the objection this time. All right.
It's the #1 rap record.
Let's move on, Mr. Steele. I understand it. You've convinced me that he's employable. So,
Well, I think the court should know it's also #2 record in any field. And I think that that's important for the court to realize there's no risk of violating condition of bond. This gentleman is an accomplished superstar in music. And I think that should weigh heavily that he would not jeopardize that by violating any condition of bond. Your Honor, America's justice system is built on the presumption that bail should be granted if there are any conditions that can be factored to ensure that the community is safe, the person does not pose a danger to the community, witnesses will not be intimidated, there'll be no obstruction of justice, the person will not, in this case Mr. Williams, will not commit a felony or any crime, it says felony, but any crime allowed on bond, and that Mr. Williams will appear in court. Because if we do it the other way and maintain people and house people and warehouse them as Mr. Williams has been, then the presumption of innocence, which is our entire standard in Georgia, is gone because he's being presumed to be guilty. Your Honor, Georgia, unlike some states, for purposes of pretrial bond, the presumption of innocence remains with Mr. Williams accused of any offense, even a capital offense, which Mr. Williams is not charged with a capital offense, from arrest and even during trial. That's Vanderford, Vanderford versus Brand, Brand. It's 126 Georgia, 67 and 70, 1906. That means, Your Honor, that prior to trial, this honorable court must view Mr. Williams to be innocent.
I do. We don't look. I understand that you're trying to meet your burden in the sense of for the 4 factors under law. So I'm going to assume that I take into account the prior testimony that you've given in this particular case. Is there anything that you want other than the updated issues as to his record release recently and employability? Is there anything else you want to augment that with?
Yes.
And then I'll let the state respond and present anything they may have to the contrary.
Yes.
Okay.
I have seen, and I've been here for every bond hearing except one, Mr. Miles Farley. I was not present for that. And I've seen this honorable court deny every person's bond who's in this indictment. But then 7 months later, approximately, I saw the state who called all these people that they are a danger to community. They cannot fashion this honorable court cannot fashion any conditions of bond that would permit bond to be granted. And then 7 months later, the prosecution for 8 co-indictees offered, and this court accepted, negotiated pleas of time served. I can't wrap that around my mind.
What does it have to do with your case and your bond? I mean, each individual defendant is on his or her, in this case, their own merit. So why does that have anything to do with you?
Because I don't believe that the proffers
Your client, I
you're
should
getting,
say.
it's fine with saying me, but I don't believe that the proffers you're getting from the state are accurate. They have been proven to be inaccurate. I heard Mr.
Unfortunately, that's the way the law goes at this point in time, and our legislature hasn't addressed that. I mean, you've asked me to take a look at that. It's a different standard, pre-trial as opposed to in trial. So, I mean, I understand that. I know you'll probably review that at some point in time, but at this point, I'm stuck with what I'm stuck with in terms of the legal posture of what the Constitution and the case law allows me to do.
There is no case that says that there's a difference between pre-trial and in-trial. That is not accurate.
In terms of the standard for motions and requirement for witnesses and live witnesses, should there be?
I misunderstood. I thought you were talking about bond law.
No.
Okay.
No, sir.
But you did grant bond. I was not present. You did grant bond for Mr. Miles Farley. And there has to be a way that—
On the individual circumstances of Mr. Farley. Mr. Williams I have to judge it on his particular circumstances.
I'm judging on Mr. Williams. I think Mr. Williams is more than bond eligible. Your Honor, we still have the same officers willing to supervise and surround a home that will have no electronics and no visitors. There will be no computer, no cell phone, and law enforcement officers outside of the house. We will pay for transportation to and from the courthouse. Otherwise, with an ankle monitor on his person, he does not leave that home. Mr. Adams and I and our other co-workers would request to meet with Mr. Williams inside that home on weekends and at nights. But other than us, nobody comes in. We can leave our electronics outside and bring paper copies because that's what I do at the outside jail anyway with Mr. Williams. Now, sometimes they do let me come in with my iPad to share discovery with Mr. Williams. I have to ask special permission, and I can do that through the court. But Your Honor, that is a factor that should be considered by the honorable court, that Mr. Williams can live at a location that can be vetted by the honorable court and law enforcement and the district attorney's office. I've gone further, not only with local police officers. If you don't like local police officers, I'm not saying anything wrong, but for whatever reason, that is not sufficient. There is a former Secret Service agent. There is a former U.S. Marshal that would take the responsibility of securing and transporting Mr. Williams in a home by himself and following every condition of bond, which we would ask for at this point: no visitors except legal, and not to leave the house except that he had to go to a hospital and on an ankle monitor. Your Honor, liberty is the norm in our community, and this custodial detention prior to trial, when there are conditions that can be fashioned, is against our law. I will answer any of your questions. Mr. O'Donnell will answer your questions, but he is Mr. Williams' manager. He will answer any questions, but he is behind Mr. Williams 100%. And Mr. Kevin Lyles is with the record label, and he also is with Mr. Williams. And I said I incorporate his prior testimony. Your Honor, I want to answer any of your questions. I want to thank you always, but this is a big case with a lot of discovery. We got discovery yesterday evening. I go through with Mr. Williams. I'm with him every day. I'm in court with him. I'm on a Zoom call with him, privileged Zoom call at the jail, or I'm with him at the jail. It is a lot better for us if he can stay awake, if he can participate and assist. And there are conditions that we have because he has the resources. That doesn't mean a resource to flee, like you heard, he can rent a plane. He's not doing that. He has too much to lose, and he's too recognizable. Thank you, sir.
Okay. Thank you, Mr. Steele. All right. Ms. Lauder, Ms. Hilton, ladies.
Thank you, Your Honor. Your Honor, to begin with, I noticed that Mr. Steele referenced this status, the state that we're in, as pretrial. I noticed that and noted it because I wanted to make certain that the record is clear that we are currently in trial. We are not at a pretrial status or state. Mr. Steele referenced the fact that he has demanded a constitutional and a statutory speedy trial. And Mr. Steele also referenced the fact that the court promised or guaranteed that his client would receive one. And in fact, the court has upheld that promise, and we are in trial. The statutes in the case law that reference bail and bond also use pretrial release interchangeably with bail and bond. And so I just wanted to point out that we are currently in trial. Also, Your Honor, since the time that This court first found that the defendant poses a risk of committing additional felonies and poses a flight risk. There has been no change in circumstances beyond what Mr. Steele has described as the defendant's discomfort, his dissatisfaction with the food that he is given, his choice to only eat certain foods that are provided. And that's it. Using the rationale that Mr. Steele employs, it's tantamount to being unconstitutional to confine anyone, given the description that he has made of his client's circumstances and his assertion that every person should have the right to be free from those type of circumstances. I want the court to take note of the fact that the legislature, in enacting the statute for which Mr. Williams is charged, said that they wanted to make certain that the community is free of intimidation and threats caused by criminal street gangs, understanding that the state has the burden of proving all of the charges alleged in the indictment at trial. We are at a position, however, where we can point to circumstances that reflect that the defendant poses a significant risk of committing additional felonies. These acts that the defendant has committed go very far back. They include acts of intimidation during the time that his brother, Your Honor, I am proffering as an officer of the court.
Yeah, let her finish, please, Mr. Chair.
I apologize, I'm opposing objection.
What's the basis?
It goes against the law for presumption of innocence. This is the charges in the indictment. The court has to presume innocence. It's an improper argument.
I believe it's just her proffer. I understand the legal requirement, and your client is presumed innocent. But I think Ms. Love is proffering how Mr. Williams is or continues to be a danger to the community.
Thank you, Your Honor.
Using the irrelevant information, it's the indictment. That's what Ms. Love is referring to.
It is not.
I don't think she's referring to the indictment. I think she's referring to acts that she claims will support the issues of bond. Bond is different from trial on the merits.
I understand that. I listen intently, and this is the indictment. That's what Ms. Love just stated.
It's a charging document, but I understand, Mr. Steele, it's different. The state has the burden. Bond is different than proof at trial. I understand that. Do you have any further objections, sir?
401 and 402 relevant.
I'm going to overrule the objection. Go ahead, madam.
Thank you, Judge. The defendant, as far back as the time when his brother, Mr. Greer, who was before the court, earlier this year, was initially set to be on trial, was one of the witnesses, and in fact, a person very close to the defendant, called the police and indicated that the defendant had messaged her, snitch hoes get murked, them and their kids.
Is this Mr. Williams referring to?
It is.
No, I did not get that.
Snitch hoes get what?
Murked, M-U-R-K-E-D.
Get murked and what else?
Murked, them and their kids.
Okay, I got it.
Your Honor, in 2015, Mr. Steele may present the objection that this is part of the indictment, but I can play the actual video where the defendant proclaims, so people lied to their mama, lied to their sister, lied to their children, and then want to get in court and tell the God's honest truth. You need to be killed, bro. That's from me and YSL. Those were his words. Judge, the intimidation factor and the risk of committing additional felonies that the defendant presents is not small. I know that you have heard proffers from prior prosecutors and you've heard evidence in previous bail hearings regarding witnesses' representations as it relates to this defendant. I can state, having experienced them myself, that the witnesses have expressed extreme reluctance. One said, with fear in his voice, he's different now. He's not the same. He moves like a man with millions of dollars behind his name. And in fact, the circumstances presented to you by Mr. Steele in both this hearing and in previous hearings reflect a similar sentiment. He moves like a man with $1 million behind his name. His hands won't get dirty, but people will enact his wishes. Since the time that we have been in this trial, we have seen it was captured on surveillance footage from inside this courtroom. One defendant who was on trial with this defendant bring to Mr. Williams Percocet in open court. Since the time that this trial has begun, we have had no less than 20 incidents, involving various crimes from drugs, shanks, and attacks being committed while the people who have been charged in this indictment are in fact confined. We have recordings of persons who are charged with Mr. Williams reaching out to other parties on the indictment, requesting permission from Mr. Williams to do harm to an opposition member who is in jail with the calling party. We have calls that are recorded of persons reaching out to Mr. Williams and conveying Mr. Williams' phone number and telling the called party, save this number under my name, just in case, the police get the phone. Everyone inside and who is associated with YSL knows who they need to keep the hands clean for, because Mr. Williams is the money that attracts the action and the willingness to act. When the shooting occurred that is referenced in the indictment of the bus for which Jimmy Winfrey was later convicted, it occurred at the same time that Mr. Williams was on stage in the other artist's hometown getting a not so receptive reaction from the audience. Your Honor, in 2015, of course, the court is aware that the state alleges that Mr. Donovan Thomas was killed as a result of conflict with opposition members, and that the vehicle, we do and can state that witnesses state that the vehicle that was used was one rented by Mr. Williams. We have proffers from persons who have pled, who have said that Mr. Williams then gave everyone money to get out of town that same night. In 2015, understanding that this particular evidence won't be used at trial, much like hearsay is inadmissible, but in 2015, Mr. Williams is found with guns and drugs inside his home, one of them purchased through a straw purchase. You would think after being arrested for that in 2022, he wouldn't have a cache of drugs inside his kitchen, a whole drug store, in fact, inside his kitchen. But not only does he have that, he has guns that have been modified with switches to make them automatic and other firearms inside his home. The person who is listed on the indictment, Mr. Jamari Holmes, as a victim of murder and for which Rodelius Ryan and Noam Blaylock were convicted, those persons, after the killing, placed on social media something akin to slime over hose. In 2022, after two persons who are friends with this defendant are gunned down and killed, the same day or a day after, a picture is posted with Mr. Chamel drinks by Kelvin Watts. And the picture has a zipper face over it and two black shells underneath. A day or two later, Chamel drinks is gunned down. The defendant is charged with being a leader of YSL. The legislature made a point of carving out a separate and additional statute for one who is the leader. Because though the leader may be the one that associates want to keep the hands clean for, they are the ones with the most influence. Jurors have come in and expressed or have shown themselves to be unwilling to be truthful out of fear. Witnesses are afraid and intimidated.
I don't know about the jurors, but the witnesses are the only ones I can listen to in terms of proffer what you're telling me at this point in time. Yes, you've actually interviewed, so
yes.
I'll make that clear.
Thank you.
All right.
Your Honor, even after, again, being arrested and having been found with drugs and guns in his home, the defendant in DeKalb County is stopped and found with drugs and guns. I believe that at a previous bond hearing, prior FTA was referenced by the prosecution. Mr. Steele's assertions regarding the nutritional content of the food that the defendant has chosen to consume while he has been confined does not rise to the level of warranting additional circumstances that merit the defendant's release during trial. We would ask that the court find that based on the actions of the defendant, he presents a risk of committing additional felonies and that he poses a risk of intimidating or threatening witnesses. Your Honor, incidents prior to the ones charged in this indictment involve the defendant's presence at other violent felonies, his participation in them, and witnesses' statements that Thug made me do it. I knew I should have followed my mind and ran with him. Other people who are named in the indictment were charged and later convicted, but the defendant is the one who managed to avoid being accountable or held accountable for those actions.
Ms. Lopez, I ask you a couple clarifications. When did the
Snitch hoes get murked?
snitch hoes get murked, and then their kids get?
That was in 2010 at the time of Quintavious Greer's trial.
Okay.
And the incidents where calls were made.
Is that more recently?
Yes, it
When was
is.
that?
Those were made in 2021.
any calls or any other things after the commencement of this particular trial, anything after December of 2022?
So I haven't heard anybody ask the jurors were they intimidated by that.
Time during 2022
Yes,
or in 2023?
yes.
Okay. All right. All right, ma'am. Anything else?
Not at this time, Your Honor. Thank you.
Mr. Steele, anything else, sir?
Your Honor, I reject the proffer. I would ask you to order the prosecution to hand to the court and to Mr. Williams' counsel, snitch hoes get murked, then their kids in 2010. That did not happen.
She's an officer of the court,
And so am I.
okay,
And you should.
I believe the law, Mr. Samuels attempted to, when he was involved in this case, to have me do that, and the law doesn't require me to do that.
Your Honor, if you rely on that, you should know what you're relying on. It does not exist. Calls made in 2021, it's a wiretap that they may be referring to. Mr. Williams is not on a wiretap. I've listened to every call.
Okay, well, I'm going to give that less weight than I would the conversations that Ms. Love has had with recent witnesses in 22 and 23.
Let me give you something out of discovery. Mr. Eppinger's mother said that Jeffrey Williams ruined her son's life, recruited him into this YSL criminal street gang, and led her son down the wrong path. Mr. Eppinger's mother is mentally ill. She's never met Jeffrey Williams, and her son never said that. That is the type of information you are being given today to rely upon. Ask the state for the proof. There's no problem. You'd ask me for the proof, and I'd say, here it is. Your Honor, this conversation that Ms. Love wants to have about the legislature made it different for leaders, she does not cite any provision of law because it doesn't exist. Bond
It's not really relevant for my bond determination at this point in time in terms of, I mean, still, I have to look at the Howell factors, and that's my principal guiding foundation.
Are you concerned at some point, Your Honor, that you're being told misrepresentations? At some point, do you just think
If that's the case, then there are other remedies for this court to undertake and other bodies that this court can refer those matters to. I have to take your proffers that you tell me as counsel when we all go through a very lengthy licensure to include a professional ethics MPRE examination given in tandem with our licensure as lawyers. So I think most people take that pretty seriously because to lie to the tribunal is pretty serious. So if I find that out later on, I'll make the appropriate decision.
and Mr. Williams will still be potentially rotting in jail. The point, the rubber has met the road, Your Honor. I'm telling the court, I'm imploring the court to, if you're relying on that proffer, please ask to see the evidence. Going back, every other term used here is in the indictment. Those are the allegations. The state wants to turn it upside down and say, well, just presume that this happened. Presume now a search that was illegal. Let's presume that as well. The failure to appear, what they didn't tell you was there was no notice given. It was a speeding ticket that got dismissed. That's the failure to appear. Your Honor, you are being given information that is not appropriate. I'm telling the court that Mr. Williams, I would not come before the court. It's the third time. Mr. Williams can have a bond with whatever conditions the court needs. It will just be the right thing to do under law, under IALA, which is AYALA. I'll answer any of the other questions, but the tour bus, Mr. Williams was, Mr. Love rather put Mr. Williams in that. Mr. Williams was out of state. He was not charged in Cobb County. And there's a memo from the Cobb County District Attorney. He's now a Superior Court Judge, the Honorable then District Attorney Reynolds, saying there's not enough evidence to charge Mr. Williams in any crime involving the tour bus shooting that involved the gentleman who performs under the name Little Wayne. That's what you're being told, though, today, that somehow Mr. Williams was involved. And I'm telling you different.
All right, sir. Thank you.
Among the members of Rock's crew. Now, the defendant, Jeffrey Williams, seated back there on you right now, he was an original member of Rock's crew. And the kind of crimes that Rock's crew did consisted of smashing grab burglaries, stealing ATM machines, things of that nature. When Rock Crew split up, YSL, or Young Slime Life, was formed. And the defendant, Jeffrey Williams, was its proclaimed leader. Young Slime Life came about and consisted of 3 or more people when it began. 3 or more people who were willing to and who did commit criminal street gang activity, that is crimes, that were intended to further the purposes and advance the directives of YSL itself. Now, there will be no evidence of a written contract or anything like that. You won't see bylaws of YSL, because this was a group of people associated in fact, who used common identifiers, common names, common colors, common symbols, to communicate with one another and to express themselves to the rest of the world. So YSL, as the evidence will show, they didn't move individually. The members and associates of YSL, they moved like a pack, with the defendant Jeffrey Williams as its head. You'll hear from witnesses, both law enforcement and lay witnesses, who personally experienced and who personally witnessed the activities, the crimes that were committed. You'll hear from law enforcement officers like Kimberly Underwood and Tyrone Dennis, whose main goal wasn't to go out in the streets and lock up people who looked like them. It was actually to touch souls in the streets, to touch young people, and to alert them of the dangers and the drawbacks of becoming a part of and becoming involved in gangs like YSL and Rock Crew. You'll hear about conversations with educators. You'll hear from members and associates of the gang itself. Now, as to how those members and associates will respond or act once they're actually in court and on the stand, that's something that I am truthfully not able to predict to you fully. But the court has given you instructions on determining and judging the credibility of the witnesses. And I trust that all of you will in fact follow those instructions. The evidence will show that YSL checks all of the boxes for being a criminal street gang. As I stated earlier, they are 3 or more people associated in fact. Their members commit crimes on behalf of the gang. They commit crimes such as armed robbery, hijacking, motor vehicle theft, theft by receiving, stolen firearms, so many stolen firearms, possession of a machine gun, and narcotic sales. And last but certainly not least, murder. What you will not hear any evidence of is that the defendants were not involved in a criminal street gang. You will not hear any evidence that they did not commit crimes on behalf of YSL. And as I stated to you earlier, what I'm saying to you now is
Let me object to that statement, please, as burden shifting.
Basis?
Burden shifting, and under Parker versus the state at 277.
Why don't we take that up then? I'll note your objection. I'm sustaining the objection. Why don't you rephrase that?
yes, Your Honor.
Ladies and gentlemen, I'm going to explain to you at the appropriate time, ladies and gentlemen, what the burden is in this case. Remember what I told you earlier, that the burden never shifts to the defendants to prove for certain innocence, they're presumed innocent, and it's only until you hear evidence that you decide is sufficient, and I'll instruct you on how you're supposed to do that at a later point in time. Okay? All right.
The evidence will show that YSL did not adhere and does not adhere to all of the customs of a traditional street gang. And the fact that YSL does not mirror all the customs of a criminal street gang, the evidence will show makes it no less a criminal street gang. The defendants on trial here today have, through their actions, displayed not only their allegiance, their alliance with one another and with the gang itself. Through their actions, they have displayed an unspoken agreement to participate in that gang through a pattern of illegal activities. And again, the head of this gang is seated in this courtroom too. The last paragraph of that poem that I read, spoke to you earlier, goes as follows. Because of his age and his cunning, because of his right.
This is argument. This is not.
What's your objection, Mr. Harvey?
That it's argument.
Okay, Mr. Harvey, hold on. Madam, it is argument at this point in time, so I'll sustain the objection, okay?
Yes, sure.
All right.
The evidence will show that these defendants, that the members and associates of YSL They knew who their leader was, and they knew the repercussions of not obeying their leader. You will hear evidence that when members and associates of YSL got in trouble, got locked up, the first person they called was either this defendant or one of his family members. Now, they didn't call him directly because he knew, and they knew, that he needed to have distance between himself and the crimes members and associates of YSL were committing on behalf of the gang. So they would reach out to his sister and have his sister reach out to somebody else and eventually get back to King's Line, as they call him. You will hear evidence that members of YSL committed armed robberies. You'll hear evidence that to slime someone is to do them dirty, and that sometimes members of YSL committed crimes against other family members of their fellow gang members. You'll hear evidence that when one of the associates or members of YSL did something to what Jeffrey Williams had perhaps considered a friend, they were threatened with their very life. Tell them to get that stuff back or they will be killed. You'll hear evidence that YSL, they had opposition within the city of Atlanta and Fulton County. That there were other gangs that were at various points in time at odds and even at war with YSL. One of those gangs was known as the IF gang, IF, Inglewood family. You will hear experts come in here and tell you more about how the Inglewood family Bloods in any way made its way down to Fulton County. You will also hear evidence about how one of the members, one of the beloved, of whom YSL considered an opposition group, was gunned down. Donovan Thomas on January the 1st, 2015. January the 10th, my apologies, 2015. Gunned down, openly and notoriously. Because the evidence will show that part of the reasons that criminal street gangs operate the way that they do is to establish dominance and to establish control and to establish fear. You're going to hear that this gang stole at least 3 lives from this community over the last 10 years. At least 3 that are referenced in this indictment. You'll find that as a result of this gang's activities, a young woman who had nothing to do with either YSL or any of their opposition was gunned down by people trying to get back at YSL for what they did. You'll hear evidence that after the murder of Donovan Thomas, no less than 50 shootings occurred over the course of the next several months. You'll hear evidence that hundreds of bullets were fired into cars, into homes, and into people as a result of the rift Hill's limelight had with other people in the community. So what are they accused of, and what are you here for today? The judge read the 4-hour-long indictment to you 12 months ago. He didn't read it to you again today, but he generally gave you what each defendant is being charged with and what the state has the burden of proving beyond a reasonable doubt as it relates to each defendant. But just to broadly touch on those, the crimes that the state is proving to you over the next several weeks include conspiracy to violate the Racketeer, Influence, and Corrupt Organizations Act. That is an absolute mouthful. So we'll just say RICO. There's no substantive allegation of RICO violations here. And by that, I mean, there's a difference. Here, the state is alleging that these defendants, they had an agreement, unspoken, but no less an agreement, to obtain property, things of value, cell phones, cars, stolen guns, through a pattern of illegal activity. The evidence will show that it's sort of like if 2 people said, okay, you know what, we're gonna go toilet paper our dean of admissions house. And they sat there thinking and talking about it, and someone overheard them and reported them to the police. And the police came and said, okay, I'm gonna arrest you all for conspiracy, for planning to go into this. The evidence will show that it's not enough that they were planning to do it. Somebody has to do at least one thing in order for those 2 people to be found guilty of conspiracy. So say one of you goes and says, let me go get the toilet paper now. Then y'all in trouble. That's what we have here, and that's what the evidence is going to show. There was an agreement among the members of YSL to obtain property and things of value through a pattern of illegal activity. And it is their actions over the course of the last 10 years. It did not stop, by the way, in 2015. It didn't stop at all. It continued up through and even into 2023, after this case was indicted, as the evidence will show. But their actions are what the state will be looking to you to evaluate and determine. Does this action show that they are agreeing to participate in this organization, this enterprise, through racketeering activity? You'll see evidence, as I stated, of not just drug sales, trap houses, drug houses, whole houses out of which drug sales were conducted, where they held long-going guns by the door, where they stood ready to act on command if either one of their number called. Who's on trial before you today is Rodelius Ryan, Tomarius Nichols, Marquavius Huey, Jeffrey Williams, Shannon Stilwell, Deontay Kendrick. And their actions during the dates that are listed in this indictment are what we are asking that you pay close attention to and you evaluate.
Your Honor, you have an objection? Yes, sir. Basis of motion. All right. Ladies and gentlemen, this is one of our breaks. I'm going to need to probably ask you to retire to your headquarters to your deliberation room, and we'll call you back in just a minute, okay, when we finish up our business, all right?
Big
So Your Honor, I'm speaking for myself. Yesterday, we received a transcript that was a transcript of an ex parte meeting that occurred on Friday.
Right, this is the
before
one,
Monday.
I'm sorry, just so that we're clear for the record purposes. This is the transcript I gave y'all at the end of yesterday that reflects Ms. Love had.
Go ahead.
The way I understand my constitutional obligations, pursuant to the 6th and 14th Amendments of the United States Constitution and corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court. For the record, and if God forbid this goes up on appeal for the appellate courts or another tribunal, commission, or administrative body, I was told based upon information and belief that when we arrived at 8:30, 9 o'clock today, we did not come into your courtroom until almost 11:30. And what I found out just recently, this is not waived, is that supposedly in chambers, this honorable court reporter at times, honorable court at times, district attorney or district attorneys from the DA's office, as well as investigators, sheriff deputies, Mr. Copeland and his counsel met together. None of the defense team, to my knowledge, was aware that this was going on. It was told, based upon information belief, that it was told to the district attorneys that Mr. Copeland intended to plead the Fifth Amendment. Then I was told, based upon information belief, that Adrian Love, the lawyer for Mr. Copeland, and this court were together, and Ms. Love made representations that John Melnick supposedly spoke with some attorneys for the accused and wrote an email to Ms. Love, to Adrian Love, stating that Mr. Melnick does not represent the witness, and that Mr. Melnick wrote an email saying F you, and then somehow that email was CC'd to me. That never.
Mr. Steele, can I interrupt you just a second? I'm kind of disturbed because that's ex parte. All that was an ex parte conversation. How did you find out about any of that?
Well, I'm disturbed too. And the reason
I'm asking you a question. How did you find out about it?
I'm going to answer you the question.
Okay.
Scuttle, if you look at SCUDDER versus state, which is 298 Georgia, 438, it's Division 2, 782 Southeast 2D 638, 2016. Our highest court says when a court meets, because Mr. Copeland comes in, meets with the court supposedly made statements, which I assume is somehow accurate based upon what you just said. We're entitled, Mr. Williams and every other person wrongly charged here is entitled under the Georgia Constitution to be present. That's a critical stage.
It's just like when you meet with me and you and Mr. Adams meet with me and others have met with me. It's those are ex parte for a lot of different other reasons, but I will certainly note that for purposes of record.
Well, I'm going forward. What I was told was that Mr. Copeland said,
And you haven't answered my question yet.
I'm not
How
going
did
to
you
answer that question.
You're not?
No, I will not answer that question.
Why will you not answer that question?
Because I want to make sure that what I say is accurate, and I'm not trying to get anybody else.
I'm asking you, how did you get this
I'm
information?
not telling the court. What I'm saying is based upon information.
Okay, well, listen, if you don't tell me how you got this information, then you and I are going to have some problems.
We can have I have problems right now.
Okay, I know. Look, I don't want to know about your problems. Okay, at this point in time, all I'm asking you at this point in time is, how did you come upon this information? Look, if the case gets reviewed, the record's going to be available for our appellate court and for whatever reason. But it's disturbing that how somehow you have surreptitiously gotten information in regards to the court's private ex parte conversation with a party. I mean,
a witness who was sworn in Friday, the court's telling, this is what I was told. If this is not true, not true. This court handed Mr. Copeland.
Tell me how you got the information.
Listen, whatever you want to do.
Tell me how you got the information, then we can go ahead and go forward.
I'm not going to say that. What I'm going to say is this. I was told, and I hope this concerns the court.
It concerns me that you have proprietary information.
Why is it
or
proprietary?
Information that you should not be having that was ex parte.
Why?
With a party.
Why?
State of Georgia.
How about the witness? How about Mr. Copeland, who supposedly announced he's not testifying and he'll sit for 2 years, and then supposedly this honorable court, or excuse me, let me rephrase that. This court supposedly said, I can hold you until the end of this trial. Ms. Hilton supposedly said, actually, all of the defendants and then all 26 people are disposed of. If that's true, what this is coercion, witness intimidation, ex parte communications that we have a constitutional right to be present for. So I understand that you're upset towards me, but I don't know what I did.
Mr. Steele, I still want to know, how did you come upon this information? Who told you?
What I want to know is, why wasn't I there? Why,
sir? I'm going to hold you in contempt if you don't tell me who tell me who this information was.
I don't want
from.
to be held in contempt.
Well,
I'm not answering that question. That's attorney-client privilege information. I am not answering
attorney-client privilege. Unless you were in my chambers, that's the only way you can figure out.
I
tell you what, I'm going to give you 5 minutes. If you don't tell me, if you don't tell me who it is, I'm going to put you. I'm going to put you in contempt because that is not attorney-client privilege.
Attorney work product privilege. I am not.
How did you get that information supposedly from my chambers? Did somebody tell you?
I'm not. You should have told me.
You got 5 minutes.
Well, I don't need it. I want to continue. This is what I was told. Mr. Copeland made statements that he admitted to killing Donovan Thomas and was. Don't take my notes. No. Glam,
Sir.
you allow another moment where Miss Love calls me that I did not do something. They have the exact image of what we got from the jail in Fayette County. That is it. And if I get another false allegation and you do nothing, I'm shocked. I'm appalled at you. I sit here day after day with this false allegation, just machine. I gave the state everything. There's been no.
Okay, Mr. Steele, would you take the podium, please, sir? All right. All right. Mr. Steele, before I recessed, I asked you, how did you get this information? And it is not covered by work product. There's only one way you could have gotten it. So I'm going to ask you again.
And I respect that. And it gives me no joy, but as you know, Georgia Rule of Professional Conduct, please check me. Rule 1.6, comment 5 reads, and this is what I have. 1.6.
I know what the rule says, but here's the thing.
Well, I'm just.
But you need to please tell me who you got it from. I'm not asking you sum and substance of anything as of yet, okay? But I need you to tell me how you got the information. If you don't tell me how you got the information, I'm going to hold you in contempt.
I understand. I don't want to be held in contempt.
And I don't want to hold you in contempt, but this is so sacrosanct to have a conversation in my chambers parroted to you and others. It is that serious.
Yeah. And that's why I raised it. It is that serious that we should have been there and it shouldn't have happened.
Sir, that's a whole separate issue. And that's why ex parte conversations are recorded.
Why would it be ex parte? You're acting like it's ex parte under seal.
Ex parte. It's ex parte because that's what the state asked me to do. It's just like when you asked me for an ex parte conversation.
I've never asked this honorable court or any court to meet with me and a witness.
Sir, you're straying off the issue.
I'm not.
The issue is how did you How did you get this information?
I understand the issue. I promise you, I understand it. But what I'm trying to ask you is, if you look at comment 5, this is how I understand the law.
You cannot you can't violate something and then use privilege. Okay?
I'm not violating anything.
Okay, but that's why I'm saying, how did you get information?
But just listen to what I'm trying to tell you. You're threatening me with contempt.
Privilege would occur. The privilege in 1.6 would occur if you were in the right place, right time to begin with. You weren't.
Let me tell you, I'm just reading from it. But if I'm reading it wrong, I'm not trying to. It says 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. So you're asking me to break, you're ordering me, maybe, you're asking me, I'm not saying you're ordering me, but to give you information, and you're saying it's not substance, but I'm telling you, I can't do that under the bar rule.
All right, well, I'm going to hold you in contempt. And you can think about it. 5 o'clock today, we'll see where you are at that stand on that point. Because no, that's not what I understand the rule to be. I've not asked you sum and substance of what was said. I asked you how you got it.
You can't do that.
Yes, you can, because I have an idea how you got it.
Well, your idea.
I have an idea how you got it, but that's improper, sir.
Your idea may be wrong, and you're asking me to listen. I told you the first time. And I'm not sure.
I don't want to hold you in contempt, but this is that serious,
Judge.
You cannot eavesdrop and get information that was not meant for you to hear at that particular point in time.
Judge, listen. I'll do whatever you want to 5 o'clock or thereafter. But what I'm trying to tell you is, Your Honor, this is so serious to me. We need a hearing. I'm moving for a mistrial. It is my understanding, based upon information belief,
from whom?
Part of it.
From whom?
Well, I'd like to get the substance first, and then we can.
Okay, well, then you'll be in custody until then, because you need to tell me how you got the information. I'm not asking you what was said. You've already kind of given us some snippets of what you said. That tells me that somebody parroted that information to you. So,
but you're assuming something because I told you already.
Well, then, other than if you were sitting, unless you were sitting in there with a recorder, or Miss Love, or Miss Hilton, or one of the deputies gave you that information, or Miss Weaver shot you a rough copy of the transcript, there's only one other person that's left.
Well, Your Honor,
and if that person gave you that information, or shared that information with you, she probably violated privilege.
Well, let me tell you two things. One, I don't know how that as a privileged communication. It shouldn't have been.
Well,
ex
because
parte.
she has a client she's supposed to represent.
Who are you talking
But
about?
anyways, I'm not going to have a.
When I got this information,
I'm not going to have any further conversation with you about this. I want to know, the question still remains. I want to know who gave you the information?
I'd like to know what information happened outside our presence. That's
All right.
really it.
He can go into custody at this point in
I
time.
think that the court needs to again declare a mistrial based upon.
Okay, and I'm going to deny your motion. I'm going to deny your motion.
I understand that you spoke with a witness outside of our presence.
And whenever, yes, I had an ex parte conversation, which is appropriate.
And you influenced the witness based on information belief, and I'd like to have that all on the record.
All right.
I mean, I don't know why that's so hard to do. If nothing happened bad, that's fine. But you're acting like, tell me who it is and don't talk about the substance. Why can't we have an issue that was outside of presence? It should not have been.
Because you got some information that you shouldn't have gotten.
Why?
Well, that's for another day.
But why?
Okay,
Why
that's for
did we
another
exclude
day.
in the first place? I didn't know about this stuff.
That's for another day. So
I raised it as soon as we found out about it.
Well,
I gave you the case I'm relying on. I assume you read it. If you didn't read it, you should read it. It's a material part, a critical part of the case. When a judge speaks with a witness outside the presence of the accused, the court has said it's right there in Division 2. That is a material or critical part of the case, and it's an automatic reversal.
Mr. Steele.
But you're acting like it's
Mr. Steele, that is not when that is not the case when somebody discloses information in a ex parte conversation that one of the parties lawfully asked me to hold.
You're not supposed to have communication with a witness who's been sworn. You know that I'm not telling you. I'm just saying if you read I'm assuming you read it. That's what it says. And you did it.
The state wishes to be heard.
You said it supposedly.
Yes, Your Honor.
And what I'm trying to get to is why did that happen outside of presence? And I need to have I'm respectfully requesting the transcript that you mentioned to be given to us so we could really understand it. And then anything that was not on the transcript, if anything, that we understand what happened outside our presence.
Okay.
And now you have put it where somehow I have to reveal, and I told you the first time, I'd be breaching 1.6. And I know you're assuming something.
I don't think you're breaching 1.6. You can't hide behind 1.6.
I'm not hiding behind anything.
And you can't hide behind, yeah, but the thing is, I think you got this information. Somebody disclosed it to you, and that's the only way you could have gotten it.
What I got.
Because unless you're sitting there, you're eavesdropping. So you can't use something ordinarily that you had no business getting to begin with, and then stand on, well, hey, we didn't give you the information, or that a party didn't give you the information. So,
Your Honor, but that's the issue, isn't it?
Well,
why aren't we?
that leads to be told. But
right now, we don't know
Mr. Steele.
why we were excluded from that.
Mr. Steele,
and I want that information because
Just
Mr.
stop.
Williams' constitutional right on the Georgia Constitution.
Just stop at this point in time, because
Article 1, Section 1,
you've already said that. You've already said
Georgia
that.
Constitution, and we have the right to be present.
All right, Mr.
And we're not waiving anything.
Yes, Madam, Ms. Lowe.
And Your Honor, excuse me. And I know I said this previously.
Yes, sir.
But we are not accepting any proffer from Ms. Lowe.
Okay, excuse me.
Okay. All right.
To the court. The court has inquired. We have no way of knowing what it is or who it was that disclosed information that was contained within an ex parte conversation. Not only was there an ex parte communication between that we requested as a state to be on record with the court, but there was communication made, I believe, to a person and his lawyer. I don't know that the reason that counsel took the podium was to address that particular issue so much as it was to try and assert an inaccurate what he calls fact and put it out there in the open as if it were true. But we certainly have the right to request ex parte communications. That's why we ask that the court reporter be present. This is a matter that the defendants did not have a right to be a part of, as this was a matter regarding a civil contempt that the court imposed upon a person for not obeying the court's directive. The state read the case that Mr. Steele cited. It does not stand for the proposition he asserts that it does. And regarding further legal support for our position, we would provide that to the court, but we are more concerned that information that is disclosed in an ex parte setting gets relayed to the parties who are not privy to that. The whole purpose of the ex parte request was so that that did not happen. And we expressed on the record our concerns and our reasons for concern regarding that. We believe that without more information about how that information got relayed to the defendants, we cannot make the kind of assertion I'd be inclined to make. So before making the next set of assertions, I would need to know how that information was made privy to them, to counsels for the defendant. We did not act inappropriately or outside of the rules of professional responsibility. And if need be, we will reach out to the state bar ourselves and ask what the appropriate remedy is for everything that has happened over the last 2 days, well, the last 2 work days, because we are extremely concerned. We have observed a number of actions on the parts of a number of people that I am not comfortable stating publicly at this time, but that would appear to call for being addressed in some other way. So as to Mr. Steele's request, I guess it was for a mistrial. I'm not even certain what all that was. I think it was probably more to make inaccurate assertions on the record public to whomever was within listening shot of his voice. And we would ask that the court strike everything that he said from the time he stood up and started talking after the court asked him where it was that he obtained the information that was made privy in counsel for this court.
All right.
And regarding Rule 1.6, Your Honor, we read 1.6 as standing there. 1.6 in no way shields Mr. Steele's answer that the court requested he give. Rule 1.6 has to do with attorney-client privilege, and that is information that Mr. Steele obtained from his client regarding whatever matters. I don't know if the information was leaked to his client from someone who was in chambers, or if the information was leaked directly to Mr. Steele. In either event, it is concerning and in no way falls under the protections of Rule 1.6. If the court would allow me a moment.
All right.
regarding further appropriate remedies, Your Honor, we would ask the court for an opportunity to further look into appropriate remedies for circumstances such as this, apart from what the court has already said, because it's grave enough when information is leaked from within the court's chambers regarding a matter that has been requested as ex parte, and we would ask for the opportunity to present to the court additional appropriate remedies that we believe are available.
All right. Sure.
And Your Honor, also, unless it's Mr. Adams representing Mr. Steele in the capacity as someone who has been held in contempt, Mr. Steele just argued whatever it is that they are trying to argue based on information we believe illegally obtained
Okay.
from the court's chambers.
I represent Mr. Williams, and my statements are in regards to my representation of Mr. Williams.
All right.
He has two attorneys.
Okay, yeah, he does, but
The court now having found Mr. Steele in contempt, if the court continues in that position, that leaves Mr. Williams represented, at least at this juncture, by myself. That puts me in a position of making sure the court is aware that I'm in receipt of the same information that Mr. Steele received. I'm of the same opinion that the court has engaged in behavior that I believe compromises and corrupts the continuation of this trial. I do believe that we are entitled to and should receive a copy of the transcript so that a full investigation can be made as to what we believe has occurred here. And so I take the same position as Mr. Steele. I am asking for a mistrial, as he did previously, and I'm telling the court that I do not believe that we can proceed at this point based upon the information that we've received.
all right. So,
And frankly, I don't believe the state has any say in that. My statements are in regards to my representation of Mr. Williams, and if Mr. Steele is going to be held in contempt, I have exactly the same position. I also do not.
well,
believe
I asked him, so I didn't ask you.
Yeah.
So, but I'll leave it at that. Okay. What is it, Mr. Sharp?
Thank you, Your Honor. As you know, I represent Shannon Stillwell. On behalf of Shannon Stillwell, I am going to be moving for a mistrial, first and foremost. I just want to clear up a few things that have been said. Today, we were instructed to come 8:30 for a 9 o'clock start. I would not be honest with the court if I said I was here at 8:30, but I was probably here at about 8:40. We did not start till approximately, I'm estimating 11 o'clock. Clearly, we figured something was going on. We were given no information about any meeting, who was meeting, what the meeting was about, or whether the meeting was ex parte or not ex parte, who requested the meeting, who was in the meeting. We were completely in the dark. And quite frankly, we kind of remain in the dark. I am not a false accuser, okay? I do not just willy-nilly accuse people of things. So I'm not going to throw out spurious allegations like the ones that have been thrown at me over the past couple days that are absurd. But I will say, Your Honor, what I do know is just based on what we've heard over the last 20 minutes, it appears there was a meeting that I knew nothing about that involved Your Honor, the district attorneys, and a witness who had been sworn in. My client was not given an opportunity to be present at this critical stage. This was a critical stage in this trial. That error is a foundational structural error in this case, and it is the cause for an immediate mistrial. Additionally, Your Honor, I believe that this meeting, again, I'm going to ask for the transcript, and I'm going to ask for the recordings as well, should they exist. But I believe that this meeting with a witness without us present may have made the district attorneys and or your honor a witness to this in this case, a material witness in this case. And finally, your honor, I'm going to ask for as soon as possible, I'm going to ask that these proceedings be halted until we can obtain an accurate final transcript for what occurred where none of the defendants or defense counsel were present for, and also the recordings of that meeting so we can see where we are. Again, I'm not going to sit up here and make false accusations or spurious allegations, but I do think we need to figure out what happened. We need to be in the know and not in the dark about what happened when a meeting occurs with a witness that has been sworn in. And we're not invited to the party. So those are my requests, Your Honor. I think it's necessary at this time to put a halt to these proceedings. I am moving for a mistrial. I have not waived anything. I just found out about this information. It is timely, and that's our stance, Your Honor. Thank you.
I've noted your motion for mistrial. It's denied. Okay, same thing. You want the Harvey? Okay, all right. Okay, Mr.
I'm adopting all of the same.
All right,
Good afternoon, Your Honor. Carlton Matthews here on behalf of Mr. Mark Huey.
okay.
We are also adopting all the arguments that have been made.
All right, sir.
Still by attorney Keith Adams, by attorney Max Sharp, by attorney Douglas Weinstein. We were here at the appropriate time. And when the court did come out, we were not made aware that there had even been an explanation that was on the record, just in the point of just letting the parties know that there had been this particular meeting. I had my suspicions that that was likely what was going on, but I could not reduce that to a fact. When the court came out, the court just got started. We believe that based upon, again, ex parte, we don't have to know the substance all the time. Just the fact that there was that meeting, Your Honor, would have at least put us on some notice that there was something that was going on even beforehand. I thought that would have been the appropriate move, but nonetheless, Your Honor, I'm asking the court for mistrial. I believe it is appropriate here under these facts and circumstances. Thank you.
All right, motion for mistrial denied. Ms. D. Williams? All right, thank you, madam. Motion's denied. Mr. Garner? Okay, so noted. All right. Okay, Mr. Steele, last time, who told you? All right, Mr. Steele's in custody. And once he clears the area, we'll go ahead and get started.
If by that point means we'll get started and resume the trial, Your Honor.
Yeah, we're gonna continue. I'm not caught nothing.
I'm not going to participate in the trial without the Steele and
You don't have that luxury at this point in time, sir. You don't. You don't have that luxury. You don't have that luxury at this point in time. You don't.
addressing the issue we believe is germane.
Sir, you all are really getting yourselves cross purposes at this point in time. Sir, I'm telling you, you are at this point in time. You made some things out of nothing. I think that you're on very precarious ground at this point in time. So I'm telling you at this point in time, he's in custody. We're going to go ahead and start. You can represent Mr. Williams. That's okay. That's fine. I'll take up the other stuff as needed, but I'm not going to take it up right now. Say again?
Respectfully, I will not. I cannot.
Sir, you have to. Well, you're going to have to do the best you can at this point in time, because you don't get to extort the court. That's what you're attempting to do at this point in time. Sir, yes, you are. What you're trying to do is, I'm not going forward if I don't get this. You know, it doesn't work that way, Mr. Adams. And I'm telling you at this point in time, I would I would just kind of govern yourself accordingly. Sir, I'm telling you, as the court, under these particular circumstances, everything will come out as it should. I don't think, sir, I don't have enough information at this point in time to address it. I don't. But I'm telling you at this point in time, there is nothing that was given, said, whatever this morning that.
If there is any accuracy to some of the information that we.
But sir, I don't even know your co-counsel won't even tell me who said whatever. Okay. And the challenge I'm having in this particular circumstance is that is such a violation of the sacrosanctness of the court's chambers and an ex parte conversation. You're just glossing over that. You're glossing over that in its entirety. No, it's not, sir. Sir, that's not what happened. That's not what happened. That's not what happened. I'm just telling you, that's not what happened.
Judge, respectfully, we are not obligated to simply accept that there's been no violation. We believe that there has been, and the only.
Okay, well then no, we're not doing that at this point in time. So you'll have a choice to make. All right, take Mr. Steele into custody, please.
Your Honor, would the court afford me one moment to confer with counsel regarding the appropriate remedy in this type of.
Okay, all right.
May I say one thing, Your Honor?
Yes, sir, you certainly may.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Farm in the
Before we call in our jury, it has been brought to the court's attention that Mr. Copeland's counsel, Ms. Bumpus, would like to be released. Is that correct, madam? Yes. Okay, all right. Sir, Mr. Copeland, is it your desire to release your counsel at this point in time?
She's fired.
She's fired? Okay. So do you wish to represent yourself in these particular, in terms of any issues you may have in this particular?
Do I got a choice?
I'm sorry?
Do I got a choice?
Yes, you do.
And what are those?
Well, you can keep your lawyer that you have right now.
I don't want her.
All right. You could certainly hire another lawyer, or the court could appoint you a lawyer.
Do what I need a lawyer for? This, what
No, it's just the court is just asking you whether it's your choice, sir.
I'm good.
You're good?
Yeah.
Ms. Bumpus, did you file an entry of appearance? All right. Did you, under the Uniform Superior Court rules, file a motion to withdraw pursuant to the Uniform Superior Court rules? I mean, I know you give an oral notice, but usually it has to be in writing, and he has 10 days to object.
Well, Judge, just for the record, I was never his counsel.
Say again.
I was never his counsel. Attorney Melnick was his counsel, and I was stepping in as a courtesy for judicial efficiency. I motion to withdraw.
Well, given the fact that you have represented Mr. Copeland at this point in time, it would seem appropriate that you do need to, in fact, file a formal withdrawal. Even though you didn't enter one, you de facto entered this case by your representation of him, or you telling the court that you did, in fact, represent him. So at this point, I'm not inclined to release you until that's done.
Okay, I'll get that done now, Judge.
Okay, all right. And he's got 10 days to go ahead and do that. So you're still going to have to be here until I have because he gets that particular period of time to go ahead and decide whether or not he'd like to hire a lawyer. That's the whole reason for the 10 days.
Well, I don't want to hire no.
Hold on. Not yet. You get that right as a party. Okay.
I think you're right.
You do. Yes. You get that right to hire a new lawyer. You get the right to do a couple things. One, to decide whether or not you can release her.
Okay.
Okay. Two, you got to decide whether or not you want to get another lawyer to be with you.
Okay.
Okay. Those are the two big things you get a chance to kind of decide. But what I'm going to do at this point in time is, since she's representing you, I'm going to make her file a formal notice to withdraw. She's orally told you at this point in time she wants to withdraw, but you're on the stand, you're testifying at this point in time. So I'm not going to let her withdraw at this point.
Well, Your Honor, I just would like to say, before he started testifying, I was fired.
I don't know that, ma'am. That's not something that I have notice or knowledge of. So, that's the whole purpose of the rule, so that we can flesh out all those things. So at this point in time, I'm not inclined to let you go at this point. I'm sorry that you put yourself in this particular situation with you and Mr. Melnick and whatever, but, Mr. Copeland does have rights in this particular circumstance. So file a proper notice to withdraw. I'll give once it's filed, if you file it today, I'll give Mr. Copeland the 10 days, but until such time as I rule upon that and he gets that and gets an opportunity to think about what he'd like to do, I'll go ahead and insist that you remain with us while he's on the stand.
Okay, Judge.
Okay. Madam, I have one other bit of business.
Also, can I approach, Your Honor, with the state?
No. What does he want to tell me?
I don't want to say it in open court. All right, it should 164 Echo Lima.
Foundation.
Yan to.
I'll sustain it.
All right, Ms.
Is your relationship with respect to Mr. Copeland?
I previously represented him on criminal cases, but for purposes of this case, I was a stand-in attorney.
And what was your intent in representing Mr. Copeland?
Okay, thank you guys for hanging out with me. And I'm gonna be streaming the other trials later on. But I just wanted to get my feet wet. And the Sagittarius.
Sagittarius! It's our time, bitch! We've been waiting all motherfucking year, and it's not time to shine! Are y'all ready? Let's go! Woo! Sagittarius! Get the fuck up, bitch! We ain't pop shit all year! Did not do shit! It's time to show out! Let's go! Ha! Ha! Ha!
Turn on the screen, hey world, it's Keys. Serving daily doses of vibes and breeze. News, community, and connections so tight. Bringing you the glory from day to night. We gather the stories from every side. Ride the waves of truth on this electric tide. Commit to making the world feel small. Catch it all on Keys, we got you, y'all. At Keezmobile show, we're living out loud. Resourceful and proud, attracting the crowd. Entertainment news, it's all in one place. Come join the fun, let's set the pace. From social threads to the community posts, we link up the hearts coast to coast. We build the ties in our local scene. Keezmobile keeps it super clean. Swipe up for the latest, scroll down for more. We're more than news, this is community lore. In a world that's big, we make it cozy and bright. Keezmobile show flies you through the night. At Keezmobile show, we're living out loud. Resourceful and proud, attracting the crowd. Entertainment news, it's all in one place. Come join the fun, let's set the pace.